Judiciary, Civil, and Criminal Jurisprudence will come to order. Since we're waiting on a quorum, we're going to go ahead and start as a subcommittee hearing the bills that are before the committee today. So first up is House Committee Substitute for House Bills 119 et al., Representative Perkins.
Thank you, Mr. Chairman. Chad Perkins, the 40th House District. That's Pike and Lincoln County. House Bill 119 we're referring to as the Corrections Omnibus Bill. There's a number of things in it, all of which I had very wide bipartisan support. One says, in essence, you can't gouge people for the phone rates in a prison system. Another one deals with deals with some drug treatment programs. The other one with parolees and being out of state and in state and how that paperwork gets accomplished. One removes the mileage limitations in a prison system for nurse practitioners. They can be outside the 75-mile range, but only while working in the prison system. We have a portion in there that would say that if you've been wrongfully convicted and determined to be wrongfully convicted in the court system, that you would then automatically get your you'd be exonerated automatically as opposed to having to go through the court system once again for that. The costs and expenses of extradition from state to state. Jail time credit is on there regarding how it's done right now. If you're in front of a judge and, for example, at a law day, then the judge has to make that determination right then and there. This would make that responsibility the responsibility of the sheriff as opposed to the judge who's in front of a courtroom full of 100 people at that time in place. There's two pieces regarding good time credits that are that have been heard many times, and they're good pieces of legislation. Some earned discharge, conditions regarding parole and probation, and Missouri's Interstate Compact Fund. And that is the different elements of that particular piece of legislation.
Can I get a show of hands how many witnesses we have here in support of this bill? Okay, how many witnesses in opposition? Okay, and it's partial opposition, as I understand. Okay, fair enough. Okay, so what we'll do is we'll start with witnesses in support, and then we'll move back and forth until we get the two witnesses in opposition done, and then we'll stay with witnesses in support. So first witness in support.
Mr. Chair, members of the committee, my name is Adam Allback, Legislative Liaison for the Department of Corrections. We'd like to go on record in support of this legislation and thank the sponsor for sponsoring the bill.
Thank you, Adam. Witness in opposition.
Partial. Mr. Chairman, Darrell Moore, Executive Director for the Office of Prosecution Services and Missouri Association of Prosecuting Attorney. On page 15, and I talked to Representative Perkins about this. This was not part of these original bills. If you look at page 15, and you're very familiar with the process, we've talked before about trying to reform restitution in those cases where people are found actually innocent under current methods. Unfortunately, when this bill was being heard on the floor of the House in early April, an amendment was added, adding 506-400, which basically would create yet another means to have a person declared actually innocent, in spite of the current law, which, as you know, there are only two ways to do that. You either go through a habeas hearing, which is contested, where you have to prove both sides, the Attorney General getting to represent, that a person is actually innocent, not just found not guilty and not just found to have a trial error requiring a new trial. There had to be an actual finding of actual innocence. This bill, 506-400, would just require by a preponderance of the evidence a judge to find, and yet another cause of action, that a person was found not guilty. We have to strongly oppose that for the reasons that we stated before. As you are aware, Mr. Chairman, we have opposed against this concept for the last 3 years. And the thing is that this was added as an amendment on the floor. I don't think anybody there clearly understood what was going on. This bill was perfected on the 5th of April. It was then third read on the 11th. There was not a hearing on the underlying bill, House Bill 327, until last week on the 13th, where we did appear and oppose it for the same reasons I'm stating now. I won't go on to belabor the point because this committee's heard our responses. We still insist that the only realistic reform for those people who are found truly innocent is the Senate committee substitute that this body has passed out. Thank you.
Any questions for Darrell? Seeing none, thank you for your testimony. Next witness in support.
Thank you, Mr. Chair, members of the committee. Sharon Galway-Jones here on behalf of Missouri NAACP and Dream.org to support this bill. It's got a lot of good stuff in it, including the restitution portion. In our view, if you do not have enough evidence to have properly convicted you the first time around, and the state has imprisoned you for a significant amount of time, you are entitled to that restitution without an additional procedural barrier. We are not talking about people who just claim innocence and are then let out. We're talking about people who have been declared to have been wrongfully convicted in a court of law one way or another. And we just feel that the further step of having to go into another contested hearing to prove actual innocence after a court has said you should not have been convicted is unnecessary, and the state should make people whole. With that, I'm happy for any questions or...
Any questions for Sharon? Seeing none, thank you for your testimony. Next witness in opposition.
My name is Ann Crowett, and my partner is on the registry. I'd like you to consider the situation we've created for persons forced to register. The current restrictions make it very hard for them to find employment, especially employment that pays the bills. Before my partner's conviction 16 years ago, he was a commercial airline pilot. He should be earning and paying taxes on $200,000 plus every year and helping the industry through a very tough pilot shortage. The airline actually didn't mind the pilot conviction, the porn conviction, but he could no longer fly because of travel restrictions from being on the registry. The only job he could find for the last decade was a bike shop earning less than $15,000 a year. So instead of earning and paying taxes on $200,000 plus over the course of 15 years, he's been on subsidized health care, he gets a rebate on his taxes. Over the course of 15 years, that's at least a couple $1 million of difference for the state. Add similar costs for the other 23,000 registrants in Missouri and nearly 1 million people nationwide. That's a lot of money. We've all been misled about the value of the registry when it comes to protecting children. A recent wide-ranging metadata study shows that, in fact, it does a lot more harm than good. Children aren't sexually abused and molested by nameless, faceless people on the registry. They're abused by people, family members and acquaintances, those they know and love and trust, those they live with. Even by the most conservative estimates, this is true for 94 out of every 100 children who are molested. Keeping the focus on those on the registry keeps us from dealing with those facts, keeps us looking in another direction, and leaves us nothing in the way of resources with which to deal with it. In truth, the recidivism rate among sex offenders is incredibly low. By most estimates, it shows between 1% and 4%, which is much, much lower than recidivism for any other crime. In fact, someone forced to register is less likely to reoffend than a person off the street is to offend for the first time. It is also worth noting the number of children who are ending up on the registry, which is supposed to be protecting them. The DOJ estimates there are 89,000 juveniles who are on the registry themselves. There are children as young as 7, many of whom are put on the registry for fairly normative behavior like playing doctor with their brothers. At this point, if you have a teenager in your home, it is more likely they will end up on the registry themselves than to be hurt by someone on the registry. One final thought I'd like to share with you is the number of people who die directly as a result of being on the registry. I recently attended a national conference on about the registry, and during our protest in front of the Supreme Court, a speaker read names and stories of people who had died or committed suicide for nearly 40 minutes. Some were killed by vigilantes who think they're doing the world a favor. Some commit suicide. At least one man froze to death because he was denied entrance to a homeless shelter during a cold snap. And the victims aren't just people forced to register. Sometimes the vigilantes kill entire families, including kids. I sent an email. I was a little bit late because I forgot my computer in the car, but I sent you this big long email with links to studies. I just think it's a waste of money. I think we've been misled what it's about, and I think we'd be better off. Only 18 states are SORN compliant. 32 states have decided this is not really helping us, and I wish that we could be one of those states. Can you double check the bill number, because I think I wrote the wrong.
I think the bill that you're referencing is House Bill 1108.
1108.
And so what we will do is, so you don't have to come up here again, we will register your opposition testimony to 1108, not the current bill that we're on. And so that way, when we call 1108, we'll have your opposition noted on the correct bill.
1108. Okay.
Further witnesses in support.
Thank you, Mr. Chairman. Senators, I'm David Clarich, today appearing. If it's acceptable, Mr. Chairman, on behalf of Senate Bill 119, in favor of Senate Bill 119, 1108, and 1133. So if it's acceptable, I'll have this testimony apply to all three. I'm appearing.
That is more than acceptable.
Thank you very much. Although I'd be happy to share this insightful testimony multiple times. I'm testifying on behalf of the Missouri Circuit Judges Association, specifically in reference to a revision of 558.031, which is the sum and substance of the underlying 1133, also sponsored by Representative Perkins. The legislation was originally passed as an amendment and as part of Senate Bill 53 in 2021. That legislation, in terms of credit for time served, changed the way in which it was calculated and had circuit judges responsible for that calculation. We don't have that information available to us. So over the last couple of years, we've worked with the public defenders, the prosecutors, the Department of Corrections to come to an agreement with that's manifest in the language that is in your current 558.031. It basically just gives the responsibility for that calculation to the sheriffs, who have readily available that information. And that allows us then to calculate and make sure that the proper amount of time that should be calculated and awarded a defendant is in fact done so. Mr. Chairman, I'd be happy to answer any questions for you.
Any questions for David? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support?
Mr. Chairman, members of the committee, Alex Eaton, testifying today on behalf of the Justice Action Network. We'd like to go on record in support of House Bill 119 and all the bills that are attached. Would like to just point out two provisions, one dealing with vocational training in prison. We see that as a positive step for those in prison. And the second piece we do have a little concern with on the probation compliance language that's included, and would appreciate some consideration on possibly amending that language. But overall, support this bill, and thank you for considering it.
The provision that you guys have some hesitancy on, what specifically is it that you'd like to see changed?
Well, we view it as Missouri's system currently in place. There's a Pew study that I will send to the committee from 2016 that shows that this is a model, and we're repealing that. So would appreciate either defining what is compliant or potentially taking it out, but do have some language that we can offer, and I've shared with other members.
Okay. Any further questions for Alex? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support?
Good afternoon, Chair and Committee. My name is Kurt Wickmer, and I represent the Missouri Catholic Conference, and we would like to go on record in support of this bill.
Great. Any questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support?
Casey Nail, representing Empower Missouri, also want to go on record in support.
Great. Any questions for Casey?
Thank you.
Seeing none, thank you for your testimony. Further witnesses in support? Any other witnesses in support? Just to check, any further witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on House Committee Substitute for House Bills 119 et al. Next up, House Bill 196, Representative Henderson, whenever you're ready.
Thank you, Mr. Chairman and committee members. For the record, Mike Henderson, State Representative, 117th District in St. Francis County, I think your home county. So bringing you 196. 196 is victim notification. I think it passed already in Senator Crawford's Senate Bill 337. It's passed out of this committee. It's taking nothing away from victims, only adding one more thing. If they're not using the MOVAN system, they can use email for those that can't be notified because of particular circumstances. Through an email, we find that a lot of victims when they move because they're afraid, they change their cell phone number, they change their address, but they usually don't change their email address. So we're taking nothing away, just trying to add another way to make sure we're notifying these people who have been victimized. Say maybe they've been assaulted or something, and they want to know when that person is going to be released, paroled, moved. So that's what 196 does. We added several other bills in there, and you've heard some of them before. The next one relates to interstate compact for adult offender supervision. This was Senator Gannon's Senate Bill 384, which also passed out of the committee. The other one The bill contains provision relating to earned discharge. This is Representative Roberts from the House. This provision would repeal earned compliance credits and would supplement and repeal with a new concept called earned discharge. I'd be happy to answer any questions if we have it on it, but I think it's been pretty well simplified and vetted. The other piece was Representative Cook's, and it's basically saying that information obtained by the Division of Probation and Parole would be able to be used in criminal cases. And I would say all these bills, I should have mentioned at the beginning, passed out of the House 153-0. The other piece, the legislation contains provisions relating to the repealing of post-conviction treatment. That was Senator Trent's Senate Bill 276, was also passed out as committee. And with that, I'd be happy to take any questions.
Any questions for Representative Henderson? Seeing none, thank you for your testimony. Witnesses in support of House Bill 196.
Darrell Moore again, Executive Director for the Prosecutors. We are in support of this bill. I want to speak in particular, certainly we're in favor of the electronic notification of victims. I appreciate Representative Henderson's bill. I want to explain the 24-month thing in response to prior testimony on the other bill. We have supported this the last 3 years. I did this when I was Greene County Prosecutor. The reality is that Pew may say it's a best practice, but it is not. Prosecutors would use the word pew in a different sense and hold their nose because no one understands the current system. When I was first in this position, we invited the Department of Corrections, and no offense, Adam, but we invited the Department of Corrections to come speak to our prosecutors to try to explain to prosecutors how this earned compliance credit works because no one could tell us. Just reading the statute, you couldn't even figure out how the thing worked. That was the purpose of the invitation. Not to name the person that appeared, but the first word, I unfortunately was not in the room to control the assistant or the prosecutors in the room, but once the speaker from DLC spoke, Senator, she admitted, we can't tell you what the formula is because we don't know what it is. It is hard to determine what earned compliance is under the statute, so it's worthless. What is better is a simpler process, which we have supported, and I did as Greene County Prosecutor, for lower level felonies. If people do 24 months, do their first 2 years of probation, and they've done everything they're supposed to do, they've paid their restitution, they've gone through programs, let them go. DLC has better things to do than to be supervising people and worrying about complicated formulas. To me, this would be the ideal system. We have no desire to keep people under supervision who have done everything they're supposed to do. So we strongly support the 24-month provision that would allow them to be turned loose sooner and let probation or parole actually focus on the folks that need to be supervised.
Any questions for Darrell? Seeing none, thank you for your testimony. Actually, any witnesses in opposition to this bill? Seeing none, further witnesses in support?
Mr. Chair, members of the committee, Adam Allback, Legislative Liaison for the Department of Corrections. This bill contains several department legislative proposals this year, and we'd like to thank the sponsor for sponsoring the bill for us and go on record in support.
Any questions for Adam? Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on House Bill 196. Next up, House Substitute. Didn't know we had those still. For House Committee Substitute for House Bills 1108 et al., Representative Hicks.
Thank you, Mr. Chair and committee members. Representative Hicks.
And Representative, I'm going to interrupt you really quick. We've been waiting on a quorum, and Senator Trent just made the quorum for us. So, Brad, could you please call the roll?
Senators Zuckmeyer,
Here.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. Got a quorum.
We have a quorum. I would now make a motion that we go into executive session. Do you have a second? Second. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary say no. The ayes have it. We're in executive session. Now make a motion that we bring up for the committee's consideration Senate Bill 432. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. This is Senator Gannon's bill that she presented on last time, establishing the Uniform Public Expression Act, also known as the SLAP Act, and unless there are any questions, I'm going to make a motion to vote do pass the Senate bill. Is there any discussion? Seeing none, I now make a motion that we vote do pass Senate Bill 432. Do I have a second? It's been moved and seconded. Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Shore, Coleman, May, Roberts, Thompson Rehder, Trent. 4-0.
By your vote of 4-0, you've voted do pass Senate Bill 432. I now make a motion to bring up before the committee Senate Bill 480. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. This is Senator Thompson Rehder's bill that decriminalizes the possession of fentanyl testing strips. I believe we've actually passed this out of the full Senate already. If there is no further discussion, I will make a motion to vote do pass Senate Bill 480. I now make a motion to vote do pass Senate Bill 480. Second. It's been moved and seconded. Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Shore, Coleman, May, Roberts, Thompson Rehder, Trent. 4-0.
By your vote of 4-0, you voted do pass Senate Bill 480. I would now make a motion to bring before the committee Senate Bill 660. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. This is Senator McCreery's bill that we heard last time that creates the Cyber Crimes Task Force. This also has passed out of the full Senate. And unless there's any further discussion, I would now make a motion to do pass Senate Bill 660. Do I have a second? It's been moved and seconded. Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. 4-0.
By your vote of 4-0, you voted do pass Senate Bill 660. I would now make a motion that we bring before the committee House Committee Substitute for House Bills 994 et al. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. There is a Senate committee substitute that was circulated to the members. I'm going to briefly walk through some of those provisions before I make the adoption motion. The first thing that is added in the Senate committee substitute is Senator Roberts' Senate Bill 215 that relates to alternative dispute resolution. That's a bill that was previously voted out of the committee. We have added Senate Bill 128, which is Senator Thompson Rehder's bill that relates to court fees and costs in divorce proceedings. That was voted out of the committee and also passed by the full Senate. We have also added to the Senate committee substitute the shared parenting provision from Senator Bratton, which also was voted out of this committee and has now passed the full Senate. We added a provision from Senator Crawford, Senate Bill 365, which relates to transfer of venue in guardianship and conservatorship cases. I know that that has come out of committee. I do not believe it has yet been voted on by the full Senate. We have made some modifications to Senate Bill 103, which was came through this committee from Senator Crawford. It extends the court automation fee, and it actually removes the sunset, which is a little different than what we had done on the floor. So that way we don't have to come back every 3 years and renew a court fee that admittedly we have to have in place for our justice system to focus. And so I believe Senator Trent also had a similar bill to this as well. So that has been added. We have added Senator Trent's Senate Bill 72, which is the Judicial Privacy Act and the offense of unlawful posting of judicial information to the doxing statute. We removed the court surcharges provision that was added by the House for the city of St. Louis. And then we have removed the offense of tampering with a judicial officer because we have now combined that provision with the Judicial Privacy Act that Senator Trent sponsored. And again, that's what the committee had done previously when we heard Senate Bill 72. So with that, we'd be happy to answer any questions or entertain any discussion. Seeing none other than the side eye that I'm getting from Senator May right now, I would now make a motion that we adopt Senate Committee Substitute for House Committee Substitute for House Bills 994 et al. All those in favor, it's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. I would now make a motion that we vote do pass Senate Committee Substitute for House Committee Substitute for House Bills 994 et al. It's been moved and seconded. Any further discussion? Seeing none, Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. 5-0.
By your vote of 5-0, you have voted do pass Senate Committee Substitute for House Committee Substitute for House Bills 994. I would now make a motion that we exit executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are out of executive session. We are back on Representative Hicks's bill, House Substitute for House Committee Substitute for House Bills 1108 et al.
Thank you, Chair and committee members. My name is Representative Hicks, District 108, out of St. Charles County here. I have a House Committee Substitute to House Bill 1108 and 1181. This bill has a wide range of public safety bills within it, and if you bear with me, I'm going to go through them here. So one of the bills in it, it amends the sex offender list to ensure that individuals that have committed child sex crimes are classified as Tier 3 offenders, which would equal a lifetime registration requirement. And additionally, it codifies the language that was ruled on in January from the Supreme Court as far as if you meet the federal requirements for registration, and it equals a lifetime registration here in Missouri, and that is due to funding requirements here in the state. This bill also defines first responders, telecommuter first responders. It requires certain individuals that work in marijuana facilities to submit fingerprints for background checks. This bill also creates a provision related to tampering with and destroying an ATM. It also creates the offense of mail theft. There's changes in this bill that relate to the change of venue for capital cases. There also is, this bill also creates the offense of delivery of a controlled substance for causing serious physical injury and the offense of delivery of a controlled substance that causes death. The bill authorizes the public governmental body to close certain records that are deemed that would endanger the health or safety of individuals of the general public. It creates the Conviction Integrity Unit. This bill also creates that no fees shall be collected for birth, death, or marriage certificates when requested by the prosecuting attorneys, circuit attorneys, and the Attorney General. It adds Class E felonies to the fees collected and redirected to crime victim compensation funds, modifies provisions related to credit for time served such that it is applied to time served after the offense occurred versus after conviction. It adds the offense of tampering with an electronic motor equipment when a person intentionally or fails to charge the equipment. This bill also strings in the pre-distribution substitute that has a second bill listed under 1118. This bill also specifies that a diligent search of a grandparent or other relative of a child removed from custody of his or her parents must be included. This bill removes the resident requirements for St. Louis Police Department personnel as well as any employee of the city of St. Louis. So pretty much what that one is doing is updating the current statute out there that has the resident requirement. This bill also requires school districts that to have bullet-resistant doors and windows on all 4 floors, subject to appropriations, and the school year beginning school year 2024 to 2025. This bill also amends provisions related to juvenile certification, modifies provisions related to investigators and the state fire marshals with the Department of Public Safety. Authorizes certain fire protection districts in certain counties to impose a sales tax, provided revenues for operation of fire protection districts. It creates provisions related to the diversion program for intoxicated-related offenses, and this adds the offense of burglary in the second degree for unlawful entering into a motor vehicle or any part of a motor vehicle. This bill also decriminalizes the possession of brass knuckles. It also provides that school officers commissioned by the district, school board, or the school protection officer will not be prohibited from carrying a firearm in any school bus, or any premise of the school function or activity. Almost done here. And it also establishes Blair's Law, which is the offense of lawful discharge of a firearm. It creates the offense of unlawful distribution or delivery of a sale of drug masking products, which is a Class A misdemeanor. Provides provisions related to drug trafficking in the first degree and second degree. Modifies the offense of drug trafficking in the first degree, and modifies drug trafficking in the second degree to remove separate penalties from when the person commits the offense. Creates provisions related to minimum training and standards for chief of police. The language also specifies that the Department of Corrections must develop a policy and procedure to help individuals to obtain vital records such as social security numbers, birth certificates whenever they're released from DOC. And with that there, the essence of the bill, like I said, has a lot of public safety provisions to help ensure that Missourians are safe across the state, and especially helping to protect our kids here in the state of Missouri. And with that, I'll take any questions.
Great. Any questions for the representative? Seeing none. Senator May?
This bill has a lot in it.
Yes, it is. It is a
Public
very big House committee substitute.
safety. Yes. So I'm hoping you're open for amendments.
Yes.
Okay, thank you.
And Representative, remind me again, the base bill, what was the original filed provision?
I'm sorry, can you say it again?
The base bill, the original filed provision that was in here before it got loved?
Yes, the base bill is, it modifies the sex offender list for child sex offenders. Like I said, it codifies what the Supreme Court has ruled on regarding funding and who has to classify as a lifetime registrant. It also takes anybody that has had a child sex crime and puts them to a Tier 3, which is a lifetime registration requirement. And there's many reasons for that. The main reason overall, though, is that we need to make sure that we're protecting kids here in the state of Missouri. And child sex offenders have a recidivism rate of, I believe it's 23% in the state. And usually when child sex offenses are actually prosecuted and reported, there's already been multiple child sex offenses that have already happened from that individual. So this is a way that we're ensuring that we're protecting the most vulnerable groups of people in the state of Missouri.
Okay, great. Any further questions for the representative? Seeing none. First witness in support.
Darrell Morgan, Missouri Association of Prosecuting Attorneys, and Missouri Office of Prosecution Service. We support the bill. We supported the underlying bill for the sexual offender registration. I just want to highlight a couple of things, well, I guess three things. One, of course, the Conviction Review Unit, which this body's already, this committee's already recommended and passed out of the Senate. But two important things. First, on page 65, we make a fix that is needed to be fixed. That crack cocaine should be treated the same as powder cocaine. We have testified for this in this bill and numerous other bills. This is also the position of the National District Attorneys Association, trying to lobby the Congress to do the same thing. The hysteria and fear raised by the original crack epidemic has proven not to be scientifically valid. It needs to be changed. A couple of other minor changes, but and things that you try to explain to lay people should happen, but don't, because we all know the bill process is maybe worse than making sausage, maybe, not to offend anybody. But on page 85, somehow when the original criminal code was passed, they did not include Class E felonies as part of the Victim Compensation Fund judgment. Well, it needs to be included, and hopefully will be. And then another item that's already passed on page 38 are changes to sections 491 and 492 regarding statements by children and vulnerable persons and the recordings of those things, which increases the age from 14 to under 18. And again, this committee, well, I don't know that it was this committee, but it's passed out of a Senate committee, passed the Senate, has been over to the House, and has passed a House subcommittee. We are certainly for that. And then another thing that may be minor in the grand scheme of things, but another fix, at some point when Division of Health and Human Services had a fix made, all of a sudden prosecutors now had to pay for death certificates, birth certificates, and marriage certificates. They admit that that was an error, so we're just asking that be fixed, that prosecutors, the circuit attorney, and the attorney general don't have to pay when they need those certificates in a criminal prosecution.
Prosecutors have an opinion on brass knuckle legalization?
Nope.
Fair
We
enough.
have no official
Committee
position.
will figure that one out then.
Yes.
Anyone in opposition? I forgot to ask when we started. Okay, 1 in opposition, 2 in opposition, 3 in opposition. Okay. Well, and any questions for Daryl now that he's taken a seat? No, seeing none. Okay, first witness in opposition.
Thank you, Mr. Chairman. Members of the committee, TJ Kirsch, on behalf of the Missouri Association of Criminal Defense Attorneys, here to speak about 2 portions of this bill. The first in regards to section 557520. It's at page 44 of the bill. Mr. Chairman, this is the section that creates a formalized diversion process in first-time DWI offenses. I'd just like to point out that it vests control not in the courts for the diversion program, but in the prosecuting or circuit attorney. Additionally, prosecutors and circuit attorneys already have diversion powers in their discretion, essentially. It also requires for a first-time offender in a diversion program to utilize an approved ignition interlock device. Not only may that not be appropriate for each and every first-time offender, but also there are, this technology is not perfect. We have clients all the time who have issues with false readings, their vehicle's not starting, things of that sort. And one of the biggest issues in this section is a successful diversion under the proposed bill results in a case being dismissed, and yet it can be used as an enhancement for future offenses. As far as I'm aware, that would be the only like section in Missouri law. All other enhancements, persistent felony offender, persistent assault offender, things like that, require a prior finding of guilt or an admission of guilt. This would not. The next section, we've heard about the sex offender registry, and that is at page 69. The Supreme Court did indeed read section 589, 400, subsection 7, earlier this year to require lifetime registration for anybody who had ever been required to register under federal law under SORNA. It is clear based on the process that that this legislature passed in 2018 that was not the legislature's intent. So a couple of things regarding the amendments to the sex offender registry. It gets more strict. It punishes the same things we've already addressed in the tiered system more harshly, and it does not fix that subsection 7 issue that the Supreme Court discussed earlier this year. So it's more strict without solving that issue, where we have a regime for removal, and yet that subsection 7 is not addressed in this proposal. Additionally, people are pleading guilty to certain things with certain expectations. If this bill passes, for example, a lot of status offenses and registration violation offenses will increase their tier and therefore affect their ability to be removed in the future. So we propose at least adding language that says those findings of guilt that can enhance the tier to be on or after the effective date and not prior to. Thank you, and I welcome any questions.
Any questions for this witness? Seeing none, thank you for your testimony.
Thank you.
Next witness in support.
Thank you, Mr. Chairman, Senators of Committee. Sean Rhodes, representing Missouri Sheriffs United, here in support. One specific thing on the bill that's been added deals with the Deputy Supplemental Fund. I think we've heard that a few times. We appreciate the sponsor. He's took on a big task and done a pretty good job putting this bill together, so we appreciate him and all them answering questions.
Any questions for Sean? Seeing none. Thank you for your testimony.
Thank you, sir.
Further witnesses in opposition. I think we had a couple of additional opposition witnesses. Good.
Sorry, I didn't know if you guys
No, you're good.
there or not. Good afternoon, committee. My name is Joshua James. I do not support, I guess, portions of House Bill 1108, specifically the proposed changes to sections of 589401 and 589414, which are the statutes regarding the sex offense registry and the petitioning process and who may petition off the registry. This bill suggests that anyone who has a SORNA obligation or an offense against a minor are not eligible to petition for removal from the registry. Essentially, it is changing all Tier 1 and Tier 2 registrants to a life sentence on the registry, and I simply cannot support that. I believe this bill is trying to address the issue causing the denial of qualified applicants who are petitioning for removal. To be removed, a person files a petition if they are fully entitled to relief according to the law. This means that they have successfully navigated the registration and restriction laws for a period of at least 10 years for Tier 1 registrants or 25 years for Tier 2. And they have completed probation, completed an offender treatment program. They've had a clean record for the entire duration and of being on the registry. They filed a petition, but they're being denied, not because they aren't qualified for relief, but because the language of Section 589400, Section 7, is being misinterpreted by the courts. The Supreme Court said that, and this is paraphrasing, this piece of the statute must be rewritten to be reinterpreted so that people can get relief from the registry. That's what the Supreme Court said. And there's been multiple cases on this. I just want to be clear that they did not say anyone that had a SORNA obligation has a lifetime registration. They did not say that. They said this needs to be realigned to the 2018 tiers that we put in place. And people are being denied their petitions for removal because of this. And it's an easy fix. This is literally one sentence fix. All Tier 1 and Tier 2 offenders are entitled to relief pursuant to 589414 based on their assigned tier. Instead of this simple change, the proposed bill is suggesting a rewrite to the part of the statute that was never broken to begin with. The petition part, I think, is good. I think it was approved by the Prosecuting Association and the Defenders Association, and we said this is good for people that are entitled to relief. So what would be the impact of this proposed change? How many people on the registry have a SORNA obligation or an offense against a minor? Well, SORNA includes offenses against minors, so that separate requirement is actually just redundant. And asking how many registrants have a SORNA requirement is like asking how many St. Louis Cardinals players play in Major League Baseball. All of them. Nearly 99% of the current registry has a SORNA requirement. Our registry was mirrored to federal SORNA law back in 2018. This doesn't mean that they broke a federal law per se. A vast majority of offenders have a state-level offense that also qualifies as a SORNA offense. What other impacts are there based on this? According to the proposed law, any Romeo and Juliet style cases between an 18 and a 17-year-old would require a lifetime on the registry for inappropriate pictures being sent, for any physical contact, as well as any misdemeanor cases, ones that were non-contact offenses where no threat of harm was directed to the victim. These cases that are currently qualified as Tier 1 under state and federal SORNA law are entitled to relief after 10 years, and they would be moved to a lifetime on the registry. It simply doesn't make sense to punish someone for a lifetime for the lesser offenses or to group them all into the same bucket when they're drastically different based on the level of harm caused to the victim, the age of the victim. Those are factors that are taken into account in the federal law and what we already have in place right now. So yeah, I agree with what the gentleman said earlier, that we're just escalating this more and more, and I don't see any data driving this. Like, why are we escalating these offenses up to Tier 3 when they're entitled to relief? And I just had one of these young men right behind me, talk about after 2 years, the DOC shouldn't have to track these people any longer. It's like, well, we're not talking 2 years. We're talking a minimum of 10 years under very strict guidelines of trying to live in society. And he wants to push it further. So I don't support that. I question the reoffense rates that he mentioned there. I'd like to see the study done on that to validate that, because I just don't believe the reoffense rates. They might be reoffense for people that are getting arrested for violations of the restrictions and things like that, or a registry violation, things like that. But they're not reoffense from new sex crimes. And that's why I don't support that portion of the bill.
Any questions for this witness?
Yes.
Senator May.
Are you providing your written testimony?
You can have this here, or you mean like online, or?
Why
No,
don't you,
here.
why don't you do this? If you could give this to my chief of staff, he will make a copy of it and then circulate it to all the members via email, if that's acceptable. Because you're wanting a copy of it.
Absolutely.
Okay, great.
I've sent emails to, I tried to email everybody, but it's not exactly this, because I didn't know this was scheduled, and I just tried to do it.
Just leave it here with Brad, and then we will take care of getting it
Who's
distributed
Brad?
to the committee. Right here.
Oh, okay. Hi,
Yeah.
Brad.
Okay. Thank you for your testimony.
If you don't
Thanks.
mind.
No, I don't mind at all. If it helps clarify the SORNA and Missouri SORA, I'm all for it. So,
Absolutely.
Yep. Okay.
Thank you.
Seeing no further questions for this witness, I would now welcome the next witness in support.
Okay. Chairman, members of the committee, Casey Nail. I'm here representing a few different organizations, the Missouri 911 Directors Association, there's a Missouri chapter of the National Emergency Number Association, the Missouri 911 Service Board, and the Missouri chapter of the Association of Public Communication Officials. Want to go on record particularly in support of the provision dealing with telecommunicator first responders, and I will not belabor this because this committee has supported that provision in a number of other bills that's passed out this year. So, thank you.
Any questions for Casey? Seeing none from Senator May.
Thank you.
Further witnesses in opposition? Anyone else in opposition? Seeing none, further opposition? All right, got to be quick around here. We're fast.
I was waiting for her to move. Can I pass these out, or you pass them out? Excuse me. Hi, Brad. Sorry. I'm Vicki Henry, and I'm president of Women Against Registry and the Foundation. And we are a nationwide organization based out of Arnold, Missouri. And Missouri, she's still laughing back there. Missouri became SORNA compliant almost immediately in 2011, and that's the same year that Women Against Registry came online. I understand that you guys don't have a lot of options because of the Supreme Court ruling, but a no vote still counts as a no vote. So anyway, and I do also disagree with the statement made about the 23% recidivism rate. That's not true. It's, again, that's violations, or that's not another reoffense or convicted reoffense. Okay, it may be a violation of some sort, and therapists are also known for saying, well, you have to admit that you have had a victim, right? Okay, whether it was a victim or a virtual victim. But every time, and I know this for a fact, every time that you say I had a victim, that counts as another victim. So you may have had one victim, but every time you go to therapy and you admit that you had a victim, that counts as another one. You can believe that or not, because I've talked to therapists. As was said, Missouri is one of 18 states that became SORNA substantially compliant, and bit the the bullet for the money. So the other states have said, a lot of them have said, no, it costs us more than it's worth to put up the systems and do all this. We know that the county sheriffs have the ability to go in and ask for the grants that are handed out in just astronomical funds from Congress. Okay, so and we went to the SMART office and we've attended their summit. Okay, and they pretty much were justifying their jobs. That's what we all came away with. They were justifying their jobs. So, and I just want to point this out, and I don't have a lot more to say, but a case in point, and we believe that everybody should be adjudicated and pay their debt to society, then be able to move on with their life without fear, without harm. There was a guy in Wisconsin about 2 months ago that was murdered by a vigilante because he looked at this person's child wrong, and he was murdered with a shovel and an animal antler. So this is the kind of things that happen to our people, and harm to their property. Okay, so one registrant in our county, in Jefferson County actually, and lives remotely, had a knock on his door. Okay, he goes to the door. It's the deputy, the sheriff, whatever. And there was two of them, and they had two U.S. Marshals with them. This guy lives remotely with his mom, who's elderly. They knew that, right? So there was 4 people there to ask one person questions, right? The deputy started out saying, "What's your phone number?" He gave him his phone number. And of course, they just freeze. They're testified. I mean, they're just petrified. But anyway, and so he gave him the phone number, and he said, "No, it's not what I have." And he asked him all these questions, right? And the guy answered all the questions. And then the deputy finally said, "I did have that number." He was just doing that for the marshals. So we're paying marshals to go out there, and there's really no need for it. But anyway, and I think it's already been said how many people are on the registry, 917,000, and that affects 2.5 million family members. And there's a considerable number that live in the state of Missouri. And again, I know that you're up against a Missouri Supreme Court ruling and SORNA. We did in last month, we did 3 events in D.C., and during one event, we spent 1 hour with Senator Hawley's staff, which is unheard of in Congress, in a meeting room with a documentary crew with us. And they were there for the whole time, even for the vigil the next day. So we're waiting to see how that comes out. Senator Schmidt didn't have time for any of our people to visit him. So anyway, we're just saying, and the last thing I'm going to say is that the downfall of all of this, of course, is the 80% recidivism rate, right? That was debunked by Professor Ira Ellman and his wife, who's a researcher. This was after their son got on the registry. I don't know why, it doesn't matter. But they started walking it back. The 80% recidivism rate that's been cited for years came from a therapist who was writing an advertisement in a Psychology Today paper in 1985 saying if registrants didn't take his therapy, they were likely to recidivate at 80%. And Supreme Court Justice now Chief Justice Roberts and retired Justice Kennedy both used those and cited them in over 100 cases. So it is just snowballed. And that's where we are today. So I'm asking you to take all of this into consideration. I'm happy to answer any questions. We will be going back to Congress.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon. Katie Gamble here on behalf of the Fire Service Alliance. We want to go on record in support specifically of Section 321.246. It's the references to the fire sales tax provision, and all it's doing is updating. So Kearney Fire Protection District has a sales tax on the books, but its designation relates to Clay County being a first-class county, and Clay County is now a charter county. And so we are updating that designation. They did pull the language from the original filed bill, and we just need to update it with the latest version of the language. But that's all that piece does.
Great. Any questions for Katie? Seeing none, thank you for your testimony. Next witness in support, or in opposition, sorry. Do we have any more opposition testimony? Okay, next witness in support.
Mr. Chairman, members of the committee, Lieutenant Colin Stosberg with the State Patrol. I'd like to thank Representative for bringing this legislation forward. It contains two of our proposals, which include the wrap-back removal of the 6-year re-enrollment requirement and then the background checks on recreational marijuana facilities. Again, I'd like to thank for his hard work and his staff on this bill. And with that, I'll take any questions.
Any questions for Colin? Seeing none, thank you for your testimony. Further witnesses in support.
Chair, members of the committee, good afternoon. I'm Kendall Seal, serve as Vice President of Policy for the Center for the Rights of Abused Children. Our mission is to protect children, change laws, and inspire people. So frequently, our pro bono law clinic receives heartbreaking calls involving children who linger in the foster care system, and oftentimes the child welfare agency does not prioritize finding relatives immediately. Instead, these children's bounce between various homes. Placement stability is core and fundamental and is crucial for a child's safety and well-being. Multiple home moves traumatize children who have already suffered, and this increases the chances of life-altering harm like dropping out of school, being unhoused, and being exploited by traffickers. Approximately 19% of those who run away are in fact trafficked. Children should be quickly settled into a relative or foster home on the path to permanency. Yet, most Missouri children in care will be placed in multiple homes. In fact, the rate of multiple placements far exceeds the national average here in Missouri, and a federal review finds Missouri falls short of ensuring children have permanency and stability, and the state has to improve efforts to place children with relatives. So the aspect of this bill that we're focusing in on, there's two on relative placement, conducting thorough relative searches on the front end of these cases, giving a time window of about 6 months for those relative searches to occur, timelining that once the notice is given, 30 days. That's pretty important to keeping the federal guidelines in place that are related to timelines in these cases. Another major factor in this bill is presuming once a child has been with a foster family for 9 continuous months, that child would then be eligible for relative status in terms of placement. And finally, the significant issue here that many have been talking about has to do with the missing children, the runaways. Over around the 2.5-year period, you had around 1,800 young people go missing in the state, and only about half of those instances of them running away or going missing were actually reported, which was very problematic for the state. Any questions the committee has?
Any questions for the witness? Senator May.
And what sections are you referencing?
The section that I'm referencing, there's two. .400 on the missing child. It should be section 2 on the diligent search.
section 2 or? Okay, hang on, I see section 1.
Section 210.305, Section 1 on 2 defines diligent search, which is what I was talking about.
210.305. Okay. Thank you.
Thank you for your testimony. Further witnesses in support?
Chair, members of the committee, Jessica Petrie here on behalf of Missouri Kids First. Missouri Kids First is the statewide association for the 15 child advocacy centers that see children who have experienced sexual or physical abuse. And as part of that, often do a forensic interview. So we're here specifically in support of the changes in Chapter 451 and 452 around raising the age for evidence admissibility. Right now, the age is up to 14. There is nothing magical that happens at age 14 that make these individuals any less children. We think raising that up to 18 for consistency makes a lot of sense. We'll make sure these children get support during the trial, whether it's the expert testimony of a forensic interview or also playing the DVD of their forensic interview, and can help reduce re-traumatizing these children who have already been through the unimaginable. So we appreciate your consideration on that piece.
Any questions for Jessica? Seeing none, thank you for your testimony. Further witnesses in support?
Thank you, Chairman. Susan Myers of the 20th. My volunteer work, I help lead a chapter of women. My focus is women in firearms and personal safety, and so I'm specifically here to give a shout out of support for HB109, Blair's Law, the 571, that is the allowing the school protection officers to be armed in other districts, and I like the bulletproof glass in the schools, but I will say it is still going to be the armed officers at those schools that are going to be the best line of defense. And if I can just add a quick about brass knuckles, the ladies I work with that have a concealed carry lifestyle with all of Missouri's gun-free zones, when you take away that ability, we consider any and every other non-lethal means. And I know some ladies that have those funky little kitty cat keychains that would probably kind of be called brass knuckles. So
I don't think I've ever seen one of those before, but I'll take your word for it. Any questions for this
I'll send
witness?
you a link.
Any questions for the witness? Seeing none, thank you for your testimony.
Yes, sir.
Further witnesses in support?
Mr. Chair, members of the committee, Sarah Schlemeyer here on behalf of Quest Diagnostics to testify in support of the provision it's on the top of page 165, section 579, or page 65, section 579, and it deals with the drug masking products. And so currently it is legal to market drug masking products for the purposes of defrauding a drug test, and we would like to see that provision changed so that you cannot market these products. It is utilizing a lot of lab resources. Quest Diagnostics partners with a lot of private employers to perform the either mandated or option employee drug testing. And a lot of times, if a drug test comes back inconclusive, you cannot tell if that is because they are using a drug masking product or because it was an invalid sample. So retesting occurs, which means that the private employer is having to use a lot of unnecessary resources. So we'd just like to go on record in support of that provision.
Any questions for Sarah? Seeing none, thank you. Further witnesses in support? Seeing none. Any further witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on House Bill 1108. Next up is House Committee Substitute for House Bill 1113, Representative Perkins.
Thank you, Mr. Chairman. Senator, hi, Brad. 1133 is actually really simple, right? Mr. Clarich did a very good job of explaining it earlier, so I don't know that I need to rehash it. I'll simply say, as you know, Mr. Chairman, law day is a very busy day in a court setting. Probably does not lend itself to being the most conducive environment for a judge to figure those things up. So returning it to the chief custody officer of a given jurisdiction would ensure that that people being sentenced to prison certainly get all the time credited to them that they deserve. And I think we can all agree that they deserve that if they've spent the time behind bars. It also has in it cocaine disparity in the sentencing. The disparity came about 35 years ago when crack cocaine was new, when we were scared of it because it was new and so forth. We know more now than we did 35 years ago. It's wrong. It's just as wrong as powder cocaine, but it's certainly not any more wrong than powder cocaine. Good news and bad news. The good news is only 8 states remaining have cocaine disparity. The bad news is Missouri is one of those. That disparity is wrong, and it's time to get rid of it. And that is the total of 1133.
Great. Any questions for Representative Perkins? Seeing none. Witnesses in support of House Committee Substitute for House Bill 1113 or 1133.
Mr. Chairman, Darrell Morgan, Missouri Association of Prosecuting Attorneys, Missouri Office of Prosecution Services. We strongly support the bill for reasons stated earlier.
Any questions for Darrell? Seeing none. Further witnesses in support.
Mr. Chair, members of the committee, Sharon Galway-Jones here on behalf of Missouri and NAACP and Dream.org in support.
Great. Any questions for Sharon? Seeing none, thank you for your testimony. Further witnesses in support.
Thanks, Chairman and committee members. My name is Matthew Charles. I'm testifying on behalf of FAM. FAM does support this bill. FAM is a nonpartisan, nonprofit organization that advocates for fair sentencing and allowing the judges to have discretion. FAM has also been working to try to change this on a federal level. There should not be any disparity between those two drugs. I'm going to speak a little bit about my situation. In 1995, I was arrested on a federal offense. At that time, as the sponsor just stated of the bill, we have a 21st century understanding of the difference between crack and powder cocaine, whereas when I was sentenced in 1996, arrested in 1995, we didn't fully understand it. And at that time, the law or the sentence was 100-to-1, and I received a 100-to-1 sentence. I was sentenced to 35 years. I served 22 years. In 2010, the law changed, making that ratio lower. I filed for a petition to be released. I was released in 2016. I was out for nearly 2 years. The prosecutor in my case appealed my release, said I wasn't eligible for release. I was ordered to return back. During that time that I returned back, I had been out almost for 2 years, doing everything that you would want a returning citizen to do. We started working with the presidential administration at that time, and we was asking for him to either grant me a pardon or a commutation of sentence. We had the belief that he would, but before that took place, the First Step Act passed. And the First Step Act made retroactive those ratio changes. And President Donald Trump signed that bill. I was released. I was out for 2 weeks. Then his administration reached out to me and invited me to attend the State of the Union in 2019 as him and his wife Melania's guest. I attended that. As a result of that, I was able to go around the country speaking to governors, legislators, and college students about the need for criminal justice reform. Thankfully, the state of Missouri welcomed me in 2019 twice. I came here in March of 2019 and in November of 2019. But as we have all stated, and like I said, I thank the sponsor, Representative Perkins, for bringing that bill. We understand that there shouldn't be a disparity between those two drugs. As he stated, they're both illegal, they're both addictive, they're both dangerous, but we believe that a person should be held rightfully accountable for their actions, and to give a person a sentence that is sometimes as a result of life for that same possession of somebody that had way more powder cocaine has affected negatively communities of color. I don't make no excuses for my wrong actions. I should have been held accountable, but 35 years being sentenced to it for a nonviolent offense was not the right sentence for me. Thankfully, throughout that period of incarceration, I did become wiser. At that time, I also became a Christian, and that opened my eyes to everything that was going on in my life, because prior to that, if you've heard my testimony, I didn't believe in God. My father was a very abusive, alcoholic person. He brutally beat me, my siblings, and my mother. And for that reason, I didn't believe in school teachers, school counselors, my neighbors, my community, or God, because they all bear witness to either my bruises or knowledge of what was going on in my household, and nobody helped. And I felt that if anybody should know, God should know. But I understood that throughout the process of time, like I said, I had a hardened heart. I was a loner. I didn't trust people, and I didn't care about people. But as I stated, when I was arrested in 1995 and sentenced in 1996, during that time, a friend of mine that was also sentenced was leaving, and he left me a Bible. And I read that Bible, and God reached down and does what he does best, and he touched my heart and changed my life. And from that point on, doors just started to open up for me. But getting back to the point in chief, I don't believe that disparity should exist. I think that it's right in a decades-old wrong that should have been done, and I'm glad that the state of Missouri, I'm glad that the state of Missouri is moving forward in the process of righting this wrong for its citizens as well. Thank you, sir.
I thought you looked familiar whenever you came
Yes,
up
sir.
here. It's from C-SPAN, it turns out.
Okay.
Any questions for the witness? Senator May? All right. Thank you for your testimony. Appreciate you being here today.
All right, thank you, Chairman.
Further testimony in support of House Bill 1133. Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, that will conclude the hearing on House Committee Substitute for House Bill 1133. No further business coming before the committee. I would now make a motion that we adjourn. Do I have a second? Yes. It's been moved and seconded. We're adjourned.